Mr. Hoskins.
Good afternoon, my lords. Beginning with issue 2, article 1013, let's just remind ourselves what is actually in issue in this part of the appeal. It's limited to the law of evidence. This appeal does not raise issues relating to the proper methodology that should be applied to assess whether a MIF satisfies article 1013 or not, whether that be the MIT, an adjusted MIT, or indeed some other method. Equally, whatever the appropriate method may be, this court is not being asked to decide whether the MIFs in this case satisfy article 1013 or not. And you're probably quite relieved to hear me say that. But equally, I think it's also important, I'm sure you have it well in mind, that if this matter does go back to the Competition Appeal Tribunal, the fortunate judge who gets to hear these 3 consolidated cases shouldn't have his or her hands tied in terms of deciding those issues. And of course, that judge will have the benefit of all the evidence before him or her, unlike this court, which has only seen little snippets here and there. So let me focus on the 2 issues which actually are an issue before the court, the standard of proof and the nature of evidence required to satisfy article 1013. Standard of proof first. The Court of Appeal held that robust and cogent evidence was needed to meet the civil standard of proof in article 1013 cases. And it clearly meant that a higher standard than the normal civil standard should apply. Otherwise, the words robust and cogent, that they repeat on a number of occasions, would be superfluous. The question is therefore whether that application of a heightened civil standard was an error of law. Mr. Turner put AAM's case on EU law. That's essentially what he relied upon. He suggested that the requirement for robust and cogent evidence came from article 1013 itself, and it was also suggested that such requirement also arises because one only comes to article 1013 after it has been established that a measure restricts competition under article 1011. But with all due respect, a requirement on the English courts to apply a particular standard of proof cannot come from EU law. You've seen Recital 5 of Regulation 1, 2003. We don't need to go back to it, but it expressly states that the regulation does not affect national rules on the standard of proof under Article 1011 or Article 1013. The recital refers to both. You've seen the Ituris case, paragraphs 29 to 32, and it confirms that the standard of proof is not regulated by EU rules. It doesn't say then there are principles in our own case law that do regulate the matter. On the contrary, in Ituris, the Court of Justice goes on to say very clearly that the standard of proof is governed by national law, subject to equivalence and effectiveness. If it were the case that the standard of proof were governed by principles found in the case law rather than in legislation, the Court of Justice would not have said that in Ituris. It's aware of its own case law. And if I can just add one other statement to what I say should be obvious from the regulation and from Ituris, I can, I'm afraid, only give you the reference because the authority isn't in the bundle. It's a well-known one. Case C8/08 T-Mobile. Advocate General Cocotte, paragraph 94, and I'll just read what the Advocate General said. For the purposes of proving an infringement of Article 81 in proceedings before national courts, it is for national law to determine the standard of proof required, subject to the proviso that the principles of equivalence and effectiveness and general principles of community law must be observed. So again, a very clear statement consistent with the other 2 sources that I have shown to you.
If it's established that community law does require robust and cogent evidence and analysis, does the principle of equivalence not require that be reflected in the way in which the national standard is applied?
No, because the principle of equivalence is that domestic rules should not be more favourable.
I'm sorry, I meant effective. I meant the principle of effectiveness.
I'm just about to come to that. It was out of my mouth. In our submission, the application of a standard of proof other than the balance of probabilities cannot be justified by the principle of effectiveness. And the reason I say that, as my Lord, you're well aware, but one sees, for example, at Turis para 32, the principle of effectiveness means that national rules must not make it excessively difficult or impossible in practice to exercise rights conferred by EU law. It has a very particular meaning, the principle of effectiveness, and that's what it is. Now, what that means in this context is the domestic law must not make it impossible in practice for a party to be able to satisfy Article 1013. So actually, the principle of effectiveness, I pray and aid on our side, because the principle of effectiveness, therefore, cannot justify a stricter standard of proof in domestic law than in community law. The principle of effectiveness is designed to prevent an overly onerous burden being applied in domestic law. It cannot be used to justify a stricter burden. Can I deal with the role of Section 60 that was raised in an exchange between the court and the bar? I think it arises this way. If there is a difference between the EU standard and the domestic standard, does Section 60 have the effect that the EU standard should be applied? And our submission is that it does not. If we can just turn up Section 60, Authorities 1, Tab 1, MS 21. First of all, sub 1, as Mr. Can for the Commission correctly pointed out, the purpose of this section is to ensure that so far as possible, questions arising under this part, i.e. under the Competition Act, i.e. under domestic law, in relation to competition within the United Kingdom are dealt with in a manner which is consistent with corresponding questions in EU law. So this isn't actually cannot apply to the application of Article 1013. It could only apply to the domestic equivalent of 1013. So this couldn't be the bridge to apply EU law to Article 1013 in the domestic courts. And as I've just explained, because of a tourist, because of Regulation 5, because of what Advocate General Cocotte said, the position in EU law is that national law applies.
Can I just be clear? Are some of the claims that we're dealing with claims based on the direct effect of Article 101 and others being purely intra-UK dependent upon Section 60 of the Section 2 of the Competition Act?
Both are relevant, but they apply at the same time to the same claims. It's not that there are some claims that are solely governed by 101 and some claims that are purely domestic, because it's said, I think, that all the MIFs and the transactions affected have an effect on trade between member states, and therefore they apply at the same time rather than either or.
Thank you.
So we are concerned with Section 60.
It would apply
directly.
It could only apply in relation to the domestic exemption provisions. So my submission is that Section 60 can't mean that the EU standard applies in relation to EU case law, but you're right, it could be argued that it would nonetheless apply to the domestic provisions solely.
Which exactly reflects the EU provision.
It's very, in similar terms, absolutely, yes. And therefore, that would be an odd situation in my submission when EU law is telling you you can't do it, and the result under Section 60 would be you must apply EU law to the domestic statute, but you don't apply it to the EU statute. That's precisely one of the problems. And our submission that if one is interpreting Section 6, that would be a very odd result. And I say there's a question of interpretation because of Section 60 sub 6, which tells us that in subsections 2b and 3, decision includes a decision as to the interpretation of any provision of EU law. And that raises a question of interpretation. Does the law of evidence applicable amount to a provision of EU law? And one could see that one could take a narrow or a broad view of what is meant by provision of EU law, and whether it clearly covers 1013. Are those words sufficient then to say that the law of evidence in relation to 1013 is caught? There's an interpretation issue, and the submission I make is that that should not be read as governing the law of evidence, precisely for the point, my Lord, you and I have just discussed. You'd have a very strange dichotomy where you're applying the EU standard to claims under the Competition Act, but you don't apply the EU standard to claims under 1013. My submission is simply that cannot be what the UK legislature intended.
Would there be a dichotomy? I mean, if the EU law, absent Section 60, did not require the imposition of an EU standard, then Section 60 couldn't impose that standard on domestic law.
Sorry, let me just break that. It's me being slow. If EU law didn't apply standard.
But you say it doesn't.
Yes.
You refer us to a tourist and so on.
Yes.
In relation to EU cases, then Section 60 can't apply that standard in relation to
the dichotomy wouldn't arise, but that's because there was no EU standard that would attract Section 60. Section 60 would never bite because there wouldn't be a corresponding EU principle.
Well, if you're right on the first point,
that's right.
Then
that's
Section
right.
60 cannot be a bridge.
That's right.
Yes.
I should also say that if it were the case, whatever the bridge, that the EU standard applied to the application of Article 101 and 102 in the domestic courts, that would actually overturn what has been the understanding and the common practice in the domestic courts for at least the last 20 years. Again, I'll give you a reference because it's not in the bundles, but the Competition Appeal Tribunal in the fairly early days of the Competition Act was faced with the question, precisely the question, of what is the standard of proof in infringement cases. And in a cartel case involving football shirts, it gave a lengthy judgment on what the standard of proof should be. And in that judgment, it cited Re B and Re H, and it came to the conclusion that the standard was the civil standard of proof under domestic law. So the reference for that is the case is JJB against Office of Fair Trading, 2004, Cat 17, paragraphs 164 to 208. And that finding that the civil standard, the domestic standard applies in competition cases has been applied consistently ever since, not just by the CAT, but by...
On what issue?
Well, it was a question of whether there had been price-fixing agreements between football shirt manufacturers, so it was a cartel case. Was there a cartel?
Right, but...
it wasn't a 1013 case.
No.
But my submission would be, you can't have a difference. It can't be that, for example, EU law or domestic law applies to 1011 and EU law applies to 1013. That would be a very odd situation. You must have one standard applying to both parts of 101.
Yes, thank you.
The JB case was concerned with domestic law only.
Now you're testing my memory. It certainly was concerned with domestic law, and I cannot remember.
The particular passage to which you refer was addressing the position in English law, in domestic law.
I can't remember. I'd need to double check. It's addressing the standard of proof to be applied in an infringement case. It was certainly domestic law. I cannot remember if there was also tucked in, because it made no difference in the case. That's why I can't remember. Apologies. And so EU law can't provide a bridge, Section 60 can't provide a bridge, and our submission, pure domestic law can't provide a bridge. I took you to authorities. There is only one civil standard of proof. It's the balance of probabilities. The inherent improbability of an event can be taken into account when applying that standard. But you already have my submissions why that can't be applied here. You can't take a monolithic approach to Article 1013 and say that all of the issues in it are inherently improbable. And I gave the example of issuer pass-through. Is it inherently improbable that a card issuer would pass through the MIF in order to encourage card use? Of course it's not. So you cannot simply make that general assumption. And the examples of this improbability in Re B and Re H are limited to factual issues And in 101.3, of course, one is dealing with economic and factual issues. Now, you are the Supreme Court. You can do what you want in terms of the law, but I do say that if one were to create, you do have that power. If you were to create a special rule here, which brought in a higher standard for 101.3, in our submission, you would be creating new law. And you might give the editors of FIPS a bit of a heart attack as well. So you certainly, can you do it? Of course you can. But I think it has to be recognised it would be a departure from the existing and well-settled domestic law on this principle. So we say the standard of proof is the normal civil standard. And let's be under no illusion, the balance of probabilities is still an incredibly exacting standard for an undertaking to fulfill because of the complexities of Article 101.3. It's in no way a free pass or a lesser easy to satisfy standard. Let me deal with the nature of the relevant evidence, the second issue that arises on this point. The second issue is whether the Court of Appeal was right to hold, as a matter of general principle, or in relation to this particular case, that all or any issues arising under Article 101.3 had to be proved by facts and empirical data. Now, one could certainly have an arid debate about whether, as a matter of law, a party could ever satisfy Article 101.3 relying solely on economic theory, but I don't think we need to grapple with that because that's not this case. MasterCard's case put forward in these trials adopted what was referred to as an adjusted MIT, and it did rely on extensive factual evidence. It relied on the factual evidence set out in the Commission 2015 survey. It also relied on evidence from the retailers. We cross-examined retailers about the benefits of accepting cards. We cross-examined them about various of the issues of the case. There was a mosaic of relevant factual evidence in this case. And therefore, the position in these cases is very different from the position before the Commission in 2007. So the real issue here is that the application of Article 101.3, whether by MIT or any other methodology, raises a very large number of complex issues. And the question is, as a matter of principle, must an undertaking provide factual evidence in relation to every single issue? Is it required to do so as a matter of law? Or is it entitled to rely on economic evidence where that evidence meets the standard of proof? That's really what we're talking about here. Now, the starting point is that it is English law which applies to the issue of evidence. And as I've already submitted, English law has, to use the phrase, an unfettered evaluation of evidence principle. Nothing is a priori excluded. An English judge must consider all the evidence in the round. Mr. Turner sought to distinguish the Salzgitter case simply on its facts, but as Mr. Khan, I think, very fairly accepted, there is a general principle also in EU law of unfettered evaluation of evidence. Now, the problem here is that the Court of Appeal disavowed that principle. And you've seen it before, but it's important if I can show you briefly again. Court of Appeal at Core 2, MS 5225, paragraph 80. Four lines down. Insofar as Ms. Dinah Rose QC sought to argue that Phillips J adopted too prescriptive an approach and that any evidence should suffice provided it meets the civil standard of proof, we do not accept that argument. So the Court of Appeal expressly rejects the unfettered evaluation of evidence principle. Now, a good example of the way in which this legal error tainted the Court of Appeal's analysis is issue or pass on. So if we can keep the Court of Appeal judgment open. Paragraph 220, MS 5255. You'll see that 220 begins on 5254. I want to pick it up in the last few lines at the top of 5255. Mr. Justice Popwell noted that neither expert sought to quantify the extent of pass-through, other than by adjectival terms. Very high, according to Dr. Niels, our expert, and a significant proportion, according to Mr. Dryden, the AAM expert. Now, first point to note is that contrary to what Mr. Turner submitted, there therefore was evidence of the extent of issuer pass-on. It wasn't a numerical figure, but there was clearly evidence as to the extent. And it was common ground, because it was Mr. Dryden's position, that it was a significant proportion. But despite that common position in the expert evidence, the Court of Appeal held that Mr. Justice Popwell was not entitled to rely on that evidence alone, because there was not empirical evidence from issuers, and therefore it wasn't possible, they said, to establish the actual extent of issuer pass-through. And there are two problems with that. First of all, where the experts agree on a particular issue, it is contrary to the unfettered evaluation of evidence to ignore that evidence because there is not separate empirical data. The question is, has the standard of proof been satisfied in light of the agreed evidence? And the second point is, insisting on empirical evidence to establish the precise extent of issuer pass-through, 70%, 72%, 75%, is contrary to the principle of effectiveness we referred to earlier. It makes it impossible in practice to rely on Article 1013. Then a similar point, you'll see, because I want to show you how the error infects the whole of this. Para 245 on MS 5259. I'll pick it up in the third sentence. To be fair, the experts agreed, at least as regards credit cards, that pass-through would incentivize card use. There was, however, no empirical factual evidence on this point, which seems to have been based on economic theory. It's the same point again. The experts have agreed, and yet it said that's not enough. And again, there's the impossibility issue, where the experts have agreed. Why do you need to come up with a precise figure? So in our submission, it's therefore clear that the Court of Appeal failed to approach each issue before it in accordance with the unfettered evaluation of evidence principle. And that's one of the reasons, in accordance with the general approach to the standard of proof, where we say this section of the Court of Appeal's judgment simply cannot stand. The fundamental basis of it, the approach to the law of evidence, is completely tainted. Let me turn to the broad acts. The crux, really, in dealing with Mr. Brealey's submissions is the need to distinguish between causation and quantum. Mr. Brealey's submission is to mischaracterize our case. He says MasterCard's case is that if you establish some direct causal link to a benefit, then you can apply the broad acts to any benefits that might arise. Now, that's not our case. Our case accepts that if you cannot show a causal link in relation to any particular head of loss, then you cannot claim in respect of such loss. The broad act simply doesn't come into play. But where one has a situation, as one can well imagine, where a judge finds on the evidence before him or her that there has been some pass-on, but that it is not possible to put a precise amount on it, that is when the broad acts can be used to quantify the extent of the pass-on. It's not used in relation to causation. Let me deal with the proper legal framework. There was some discussion of that yesterday afternoon. EU law does not regulate quantification. And as Mr. Brealey finally accepted, when it was put to him on a number of occasions by Lord Sales yesterday, it is therefore for national law to determine quantification, subject to the principles of effectiveness and equivalence. And therefore the EU cases referred to by Mr. Brealey are not relevant, because it's for national law. But in any event, what those cases confirm is that the question whether a charge has or has not been passed on in each case is a question of fact to be determined by the national court, which is free to assess the evidence adduced before it. And you see that, for example, in the Weber's Wine World case that Mr. Brealey took you to. I'll just give you the reference. Authorities, Bundle 10, Tab 86, MS 430. But that's the proper framework for this. There's no magic to be pulled from EU law. It's domestic law that applies subject to equivalence and effectiveness. Now, you have my submissions. I made them in opening as to why the Broad Act should apply in favour of a defendant. The need to ensure compensation, the need to avoid overcompensation, and the need to avoid the risk of double recovery. But another reason in support of our position came out again in the debate between the court and the bench. And that is the point that Lord Sales, I think Lord Reid made, that all the evidence, documentary and witness lies in the hands of the claimant. And in those circumstances, it is obviously just and fair that the Broad Act should apply to a defendant. That's an additional reason why that position should apply.
Let us try to understand, or maybe can you help me to understand, how the issue arises in practice. We don't have the claims in front of us, but we were told, I think, by Mr. Turner, that the claim for damages is based on loss of profits.
I'm going to come, is this the more general point, my lord?
Yeah.
Sorry to interrupt.
Yes.
I'm going to come to that
Oh,
now.
very well.
Because let me try and show you how
I'll be patient.
no, that's very kind. I can't necessarily give you the answer, but I can certainly, I think, frame the issue for you, hopefully in a way that's helpful. This issue really sort of arose in the tribunal, and it reflects an argument that we made. If we can go to the tribunal judgment, which is Core Bundle 2, it's paragraph 455 at MS 5564.
Sorry, page.
5564.
Thank you.
So this is the tribunal at 455. They find, we noted that when faced with an unavoidable increase in cost, and that could be an overcharge on a MIF, for example, passed through into the MSC, an enterprise can do one or more of four things. It can make less profit, or incur a loss, or if loss-making, a greater loss. Now that is certainly something that could be claimed by way of damages. Or two, it can cut back on what it spends money on, reducing, for example, its marketing budget. That is not a head that could be claimed as compensatory damages. It's a saving by the relevant company. Three, it can reduce its costs by negotiating with its own suppliers. Again, that's not a head of loss that falls within compensatory damages. Or four, it can increase its own prices and pass the cost on to its purchasers.
I'm not sure about two. And I take your point in relation to three, but so far as two's concerned, I mean, if you're seeking damages on a conventional Livingston and Royards basis, you're entitled to be put in the position you would have been in if the tort hadn't been committed.
Yes.
And if the tort hadn't been committed, they would presumably have maintained their marketing budget and so forth. The fact that because they'd suffered the loss, they made economies elsewhere so as to be able to absorb it, doesn't mean to say they didn't suffer a loss.
Well, if you cut back on your marketing budget, that doesn't, it's slightly similar to the point you've been putting to Mr. Brealey. It doesn't automatically translate into a loss. Cutting back your marketing budget might mean you make less sales, and that leads to the point that you raised, I think, with Mr. Turner, which is there is a head of damages in tort, which is that a company which has suffered harm as a result of competition law infringement might be able to show that it has suffered a drop in sales because of the effect on it, because, for example, it has cut back what it spends money on in advertising.
But even if only 3 and 4 are relevant, i.e. squeezing the supply chain or increasing your prices and passing on that way, it's a formidable exercise in the context of a business as sophisticated as a supermarket to show pass on.
Absolutely.
Yeah.
I mean, that's what this judgment shows. But the reason I show you this is because it ties in with the question was put, or the point was put, just because your loss isn't equivalent simply to the extent of the overcharge. the claimant has to show that it has suffered a diminution in profits somehow. And if you look at paragraph 463 on MS 5566, the tribunal says, as a last resort, Sainsbury's would make less profit. It is to be inferred that this did not in fact occur over the claim period. So the tribunal found in this case that Sainsbury's could have done one of these four things, but one of the things it did actually make a finding on was it did not suffer a loss in profit. And it refers to the evidence that the tribunal relied upon to make that finding.
I'm not quite sure how that reasoning works, because they might be making profits or elsewhere, which make up for the dividend.
I understand.
But if they hadn't been subjected to the tort, they'd have made even more profit.
Yes.
Yes, I simply show you what the tribunal's finding was in the evidence before it. One might question whether it was correct or not. But in this particular case, the tribunal said it did not, in fact, suffer a loss of profit, which is one of the four heads that I just showed you.
Did the, in the period of the claim, was the MIF altered significantly?
No, not to my recollection.
Well, would one expect to see any change then?
But I'm not trying to reopen the tribunal judgment. Let me make this absolutely clear. We're stuck with this. I'm simply taking it through because the court made the point that the extent of the overcharge doesn't equal the extent of the loss that can be claimed in tort.
That may be so, but I mean, I would think that in quite a lot of cases, in pleading terms, maybe simplistically, and that's what the case was discussed, simplistically as a first round, the claimant will be saying, well, the effect of the MIF was that I was subjected to increased costs, which I ought to have been subjected to, therefore strip those costs out of leaving everything else in place, and that is a loss of profit. And then, in pleading terms, it would be open to the defendant to try to expose that that's overly simple, and in fact, the quantum of the loss of profit cannot be equated to the MIF. But the starting point, I would have thought in many cases, will just be that simplistic picture. I had to pay more, and I ought not to have paid that.
Maybe it is the case you see pleadings like that, but whether that's then the correct legal analysis comes into sharper focus when one gets to trial. And then there will be a question of, because the burden of proof is on the claimant to prove its loss.
Well, then you get into the issue about, well, what happens where the defendant wants to say, well, that's a very simplistic case that you're presenting to me, claimant. In fact, you mitigated your loss. In fact, so not failed to comply with the duty to mitigate, but you did in fact
That's right.
manage to avoid the loss. By
Yes,
doing
that's one of the
things,
issues.
which is the pass-on case.
I agree. That's one of the issues that could arise, or it could be numbers 2 or 3 in the tribunal's
So I mean, if one goes in this rather, it may be slightly simplistic way of putting one's case, but pleadings do go in on a simplistic basis. The claimant pleads, it's a loss of profit claim, but I can quantify the loss of profits as being equivalent to the MIF charge that I was forced to bear, or that element of the MSC, which is the MIF.
Well, I absolutely agree, and that's the way one sees pleadings. Whether, in fact, if the law is not, if the discussion is again that's been happening between the court and the bench, if the law is not as was previously thought, then it may well be that the pleadings will have to change. But absolutely, and if you're asking me what the practice is, does one see that? Yes, one sees that. I say I'm not here to. I say I'm not sure I can give you the answer, but you expressed an interest in this issue, and I thought the tribunal judgment, at least in terms of showing the sorts of ingredients that go into then deciding whether a claimant has suffered loss or not, beyond simply the extent of the overcharge, I hoped might be useful in framing that consideration when you come to it.
When you see the discussion, it's very interesting to see this. At 464, they conclude that how Sainsbury's dealt with the costs is unknowable, but that viewing it matters at a high level of abstraction, they would have passed on to consumers what they could. They repeat at 465 that it's unknowable and it's impossible to say what proportion was dealt with in various ways. And then in 467, last sentence, we agree the likelihood will be passed on is not insignificant. Oh no, because we passed on increases because the cost is not insignificant, and one that's monitored. So, I mean, in that situation, the court wouldn't simply ignore passing on because it was unable to put a precise figure on it. I mean, that, I'm inclined to think would be an example of a situation where you would have to take it into account in a rough and ready way, as Lord Shaw had.
My Lord, I wish you'd been sitting in the tribunal, because that was our submission, but it was rejected. But absolutely.
And in that event, obviously, one party would be arguing for a lower proportion, another party would be arguing for a higher proportion, and the court just has to do the best it can on the evidence that it's heard.
Well, that was our submission, yes. To be fair, the actual hook that the tribunal found against us from was they said we hadn't established a sufficient causal connection. And they go into sort of distinguishing, even although they found here that it's likely that it would have been passed on, because we couldn't show a sufficiently direct, because there's X fraction of a pence on a MIF, that equates into the price of baked beans. That's how they found we failed. So I don't want to, again, I'm not trying to reopen this now, but I am trying to help the court by framing the sorts of questions that you were asking.
Yeah, thank you.
Finally, on this, Mr. Brealey referred you to various EU cases, including San Giorgio, and suggested that those cases indicated that the burden in relation to pass on lies on the defendant. But with respect, that's not correct. What the EU cases establish is that one cannot have a presumption in law that charges have been passed on, which the taxpayer must overturn by evidence. What the cases repeatedly say, you can't have a presumption, and that the national court must be free to decide the issue of pass on the evidence before it. What those cases don't say is that the burden is on the defendant. And I'll give you the references for those. It's San Giorgio, Authorities 7, tab 62, paragraphs 4 and 14, that's MS 3048 and 3051. It's Comateb, Authorities 10, tab 84, paragraph 23 at MS 4228, and paragraph 25 at MS 4229. And finally, Weber's Wine World, you were taken to, Authorities 10, tab 86, MS 4275, paragraphs 93 to 96, which appear at MS 4304. And the final point I can deal with very briefly is just in relation to issue 1. Again, happy to adopt Ms. Rose's submissions. I've made the point, and I don't think it's been contradicted since, that the essential factual and evidential position was the same in both the MasterCard cases as in the Visa case. And as I said in opening, in response to a question from Lord Hamblin, that's not surprising because it was the same experts for the retailers. It was Messrs. Dryden and Von Hinton-Reed. So as you would expect, they gave the same answers in our trial as they gave in the other trials. And I'll just tell you that the references to the evidence where it's common position and where it's the evidence of the claimant's own experts are set out in full in our written case at paragraphs 40 to 84. That's Core Bundle 1, tab 17, MS 4933. And given that the essential facts are either agreed or were agreed by the claimant's experts, we say if Visa wins, we must be in the same position. Well, unless you have any further questions, then...
Thank you very much, Mr. Hoskins.
Thank you very much.
So, I think, Mr. Turner, it's now for you to open on your cross-appeal.
That is so, my lord, and to manage expectations is my calculations of the scheme of the remainder of this afternoon. I was 25 minutes over before, so my 50 minutes I'm going to reduce to a 35-minute address now with a 10-minute reply. Miss Rose went 10 minutes over her half hour of their hour reply, and Mr. Hoskins another 10 minutes. So they reduce to a 30-minute answer.
I'm sure we'll manage.
So we will work on that basis. Yes. My lords, the cross appeal. AAM's appeal was allowed. And I ask you please to open up the Court of Appeal's judgment at Core Volume 2. Start with the Court of Appeal's express reasoning that led to its order. Go first to page 5262, where you will have paragraph 257, just below letter C. The judge should have concluded that in the absence of any evidence as to the actual extent of the pass-through, MasterCard had failed to establish by robust analysis and cogent evidence or otherwise, a sufficient causal link between the MIFs and any net benefits, so their claim for exemption failed. Following paragraph 258, look at the last 4 lines below E. On the contrary, the judge should have concluded on the basis of the evidence before him that the first condition of 1013, the benefits requirement, was not satisfied, so MasterCard had not established entitlement to an exemption. And 259, below that, the last 3 lines above 260, letter H, in our judgment, had the judge carried out the necessary balancing exercise, he would inevitably have concluded that MasterCard could not satisfy the second condition either. Records halfway up that paragraph, as I had alluded to earlier, corresponding to paragraph 94. In the AAM party's appeal, it is common ground that this requirement is looking at the position of the merchants and is only satisfied if the merchants were no worse off. That was the litigation position. So that conclusion was reached by the court. This was in view of the failure by MasterCard to produce necessary evidence capable of meeting the claimant's case, and that was in turn because they did not try to obtain it. The failure related to a gap in respect of key evidence from MasterCard's issuing banks. And may I invite you to go to page 5227, please. There you have paragraph 89. You will see from that that in the first line, the court states, in order to satisfy the benefits requirement, and I comment you will have seen from the paragraph you just read that that is the first condition and is described in those terms by the Court of Appeal, a balancing exercise is required. Then they set out the test. They give the reference as the source for that authority to the Court of Justice's decision at paragraph 234. I believe I therefore misspoke earlier. I'd referred to 2 other paragraphs which do say the same thing, 237 and 242, but it is correct that they refer here to 234. Essentially, they took that position as the law. It was undisputed, and it is, as I say, firmly rooted in the MasterCard's Court of Justice judgment. You then go forward 1 paragraph to paragraph 90. That paragraph considers what the factors to consider in the balancing exercise need to include in this particular case. That included, towards the bottom of that page, last 2 lines, the fact that not all of the income received by the banks is actually passed through to their customers, the cardholders. Some of it is retained as profit. And then in the case of the merchants, if you go over the page, the fact that they pay this amount on every transaction, even where the cardholder would have used a scheme card anyway, irrespective of the MIF. Paragraph 94, letter H, on page 5228, there was agreement, as I say, about what the second condition involves too, for the purpose of our proceedings, and you've seen that paragraph already. And with that, therefore, I go to the main part of the reasoning of the court, which led to their conclusions. Paragraph 242 at the foot of page 5258. The heading here, under letter J, is discussion and conclusions on the AAM party's appeal. and you'll see from paragraph 242 the question raised in the case whether the reasons for the issuers promoting card usage were either dependent on the flow of the MIF income or whether the issuers had wider economic reasons for doing what they did and would maintain the services anyway. The trial judge commented on the exiguous documentary evidence on issuer finances and the failure to call any witness with contemporaneous experience as an issuer. That is something you get from paragraph 408, referred to in the third line down. I took the court to that yesterday, and I shan't spend further time going back to it. But that was Mr. Justice Popplewell himself commenting on that failure on the part of MasterCard. Then you go to paragraph 244, below that at letter D. This is one of the most important paragraphs for the purpose of the cross-appeal. The court comments, this was a matter, the lack of the evidence on the issuer finances, what they keep as profit and what they don't, on which only factual evidence from the issuers could have remedied an obvious gap in MasterCard's evidence. We were unimpressed by arguments on behalf of both schemes that such evidence would have been difficult, if not impossible, to obtain, given that, as the judge found, MIF income was not an isolated pot of money. Issuing banks receive the MIF income, they must know what they do with it in broad terms. Documentary evidence could have been obtained, and so forth and so on. Witnesses could have been called to speak to these matters. We accept that a ledger approach of giving precise figures for MIF pass-through might not be possible, but see no reason why issuers could not provide some estimation of the extent to which MIF income is passed through. It was not suggested that MasterCard had attempted to obtain such evidence from issuers, but had been unable to do so. It simply did not attempt to obtain any such evidence. 245, to which Mr. Hoskins just took you, below that, the point made is that there was no evidence of the extent of the impact on card usage of any measures taken by the banks, and by extent one is talking about something more than the broad brush adjectival terms commented on by the judge later. If you then turn the page to 5261, 2 pages on, at 252, this is again on the treatment of pass-through. If you look just above letter D, Mr. Dryden, the claimant's expert, accepted a significant proportion of income was passed through to cardholders. Here we are. His point and the AAM party's case was that in circumstances where it wasn't 100% or was materially incomplete, and MasterCard couldn't establish by evidence the extent of pass-through for the purpose of the first and second critical steps, the extent to which MIF revenue was used to incentivize card use and did in fact stimulate additional card use could not be established. Now our case, there you have a whistle-stop tour of the central reasoning. Our case is this. MasterCard had a full and fair opportunity to adduce the evidence required, if it existed, in an attempt to discharge the burden it carried under Article 1013. And that is why we rely in the cross-appeal on the propositions which are set out at paragraph 22 of our own written case that you find in Core Volume 1 at page 4967 in tab 18. Right at the foot of that page, in paragraph 22, we rely on the following propositions. In circumstances where in a final trial between private litigants to determine their rights and obligations inter se, each side has had a full and fair opportunity to bring forward all the evidence they want to bring forward in support of their case, and where the appellate court has concluded on the basis of that evidence one party ought to have won, the court should grant that party a final remedy corresponding to the judgment. That's necessary to do justice to the parties to achieve finality and avoid the court enlarging on the dispute as the parties have themselves chosen to frame it. And the remaining two subparagraphs relate to the power of remittal under the civil procedure rules. And at C in particular, it should not be used if the appellate court concludes a litigant should have won at trial. The court is concerned with doing justice in the individual case. It's not a search after truth. In a wider inquisitorial sense, there must be finality in litigation. Now, my Lord, I propose to organise the remainder of my brief submissions as follows. I will emphasise the point that they had a full and fair opportunity to produce the evidence needed to support their positive case, and then I will deal with MasterCard's reasons for opposing our grounds and supporting the reasons given by the Court of Appeal for its decision to remit the proceedings rather than ruling definitively in favour of AAM on liability.
Well, the curious thing is they seem to have done both when you look at their order.
That is right.
They do, in fact, declare, they preserve the part of Mr. Justice Popplewell's order which held MasterCard liable to your clients. But then they go on to say that 1013 has to be looked at again.
That is right, and that is exactly our point, that they should not have taken that second step. And that is what I now turn to. Full and fair opportunity, I draw attention simply to the litigation context. MasterCard, the defendant, had itself been the addressee of the European Commission's procedure and the European Court judgments on appeal, which had found against them, precisely because of recital 730 of the decision, a deficit of concrete evidence, including, and I've given you the references, on issuer pass-through, for example, in the Commission decision, paragraph 741, and I took you also in the main address to the General Court's point about the need to have a full picture of the business economics of the issuing banks. That was the General Court judgment at 211, referring back to paragraphs 106 to 108. And secondly, to have evidence on whether merchant benefits were sufficient to offset their losses from paying the inflated fees on every transaction, for example, paragraph 740. So, MasterCard could have been under no doubt about their exposure if they failed to adduce concrete evidence referred to in the litigation to which they had been subject themselves, in particular, evidence from the very people you would expect to have the necessary information, the witnesses with contemporaneous experience as an issuer, the very individuals that Mr. Justice Popplewell commented had not been produced. The finding made by the Court of Appeal at the end of paragraph 244, which we have read, that MasterCard simply did not attempt to obtain any such evidence was telling. And that is because MasterCard will have made its own assessment about what favoured its position and what did not favour its position. I turn then to the Court of Appeal's reasons for choosing to remit the 1013 issue for further reconsideration in our case, despite these matters, and to MasterCard's arguments in its written response case in support of those reasons. The Court of Appeal's reasons on remittal are contained in a single paragraph in the judgment, paragraph 366, which you find on page 5281. Now, in 366, I'll take it in stages, 4 points. First point, the Court of Appeal reasons, reading it from the beginning, that it's not certain that if the trial judge had had the benefit of the Court of Appeal's ruling and had thus been fully aware of the need for data and facts to prove an exemption, that MasterCard's case would have failed in its entirety. And in that regard, the Court of Appeal refers to the fact that in the separate Sainsbury's proceedings, Sainsbury's and the CAT had accepted that there was a lawful level of myth. So those are what it says. Now I pause there and say this. There are two major flaws in that reasoning. The first is that it doesn't meet the essential problem identified by the Court of Appeal itself, notably in paragraph 244 of the judgment. There was a deficit of evidence. There was an obvious gap. The obvious gap led to only one outcome. As it happens, Mr. Justice Popplewell was, of course, aware of the tribunal's decision, subsequently overturned by the Court of Appeal because of inadequate evidence, and of Sainsbury's position when he reached his decision. The second major problem with that reasoning is that the relevant question should be whether the litigant, MasterCard, which is the party responsible for marshalling the evidence to try to discharge its burden of proof under Article 101, third paragraph, made its litigation choice with its eyes open. MasterCard seeks to answer this objection in its written response case in two ways. First, it suggests that the decisional practice of the Commission following the infringement decision had changed the landscape concerning the evidence that it could reasonably expect to need to adduce in court. And I have dealt with that point under ground 2 in the main appeal. MasterCard is referring essentially to the undertakings it gave to the Commission to close the procedure in 2009, and then the visa commitment decisions which followed. But the Commission was crystal clear that those were not automatically to be equated to an Article 1013 exercise. Now, in that connection, I showed you the express wording in the MasterCard undertaking. They were told by the Commission that this test, the MIT or the tourist test, was not, to use a colloquialism, a silver bullet, and that it would depend on the circumstances of the case. The reference was Appendix 1D, page 7165. And exactly as stated in those terms in the undertakings with MasterCard, when you go forward to 2015, before this litigation starts, before Mr. Justice Popplewell at the trial, it is replicated in the same terms in the cost of cash publication by the Commission in March 2015.
See, the operative part of the order seems to be paragraph 15 on page 5195, which remits each of the appeals to the tribunal for reconsideration, not retrial, and goes on to say over the page, about 10 lines down, that it will not be open to any party to advance a new case or to adduce any fresh evidence on the remittals for reconsideration. However, the parties to each of the proceedings may rely on evidence from the other two proceedings.
Yes.
So presumably that's your complaint, that MasterCard, having failed to lead the evidence in front of Mr. Justice Popplewell at the trial, can now benefit from evidence that was led at the other two trials.
Precisely, my Lord. That is a very large part of it, which is to say that I focus on the fact that you have had a fair trial between two litigants. They could not be said to be well-resourced or to have approached this without their eyes open, and therefore to have made their litigation choices. And yet we are being put to the expense now of a further extremely time-consuming and expensive procedure into which evidence will be introduced from other sets of proceedings.
On evidence which you didn't have an opportunity to test.
That's right, yes. And I will, and indeed, so far as MasterCard is concerned, it chose not to bring forward in this litigation certain essential evidence with its eyes open. So with that, I need to address, one final point in relation to this first part of the court's reasoning in paragraph 366, which is that MasterCard, in its written response case, makes a rather Delphic comment, paragraph 24 of its document, that if they had been aware of the position the Court of Appeal would subsequently adopt, they would have referred in a note that they produced to unspecified further evidence of always card transactions and the extent of issuer pass-through. Now, we have made determined efforts prior to this hearing to obtain clarification from MasterCard of any specific evidence they have in mind, and we have alerted the court registry to that. So it's on the file. MasterCard has said that it refers to no specific evidence. So with that, I turn to the second of my 4 points on the Court of Appeal's reasoning in paragraph 366. The second point in that paragraph is that if Sainsbury's had made a concession in its proceedings and the CAT made a finding of a lawful lower level of myth, then simply giving judgment in favour of the claimant AAM might result in what they refer to as an unjustified windfall for AAM. That's how they phrase it. Unjustified windfall between letters D and E. This can only mean, what can their thinking process have been? That the Court of Appeal was suggesting that there was a need to be certain to reach an objectively right answer by reference to frankly thin indications from parallel cases, and that was an error of principle. We've referred in our written case to Lord Wilberforce's famous statement in the Air Canada decision in 1983. And if you have Core Volume 1 and turn in it to page 4996, we set out there Lord Wilberforce's words. In a contest purely between one litigant and another, the task of the court is to do and be seen to be doing justice between the parties. There's no higher or additional duty to ascertain some independent truth. It often happens from the imperfection of evidence or the withholding of it, sometimes by the party in whose favour it would tell if presented, that an adjudication has to be made which is not and is known not to be the whole truth of the matter. Yet if the decision has been in accordance with the available evidence and the law, justice will have been fairly done. So that is my second point on the Court of Appeal's reasoning. The third point is this. The Court of Appeal went on to say that the just course for it to take would be for the issues under Article 1013 to be reconsidered in all 3 cases. Now turning, my Lord, therefore, to the point you have just raised with me, based on the same principles. This, we say, was an error, both for the reasons I've already given and because these issues would in any event not be reconsidered based on the same principles as between the different cases. There are 2 factors. First, the Court of Appeal had separately laid down, and it enshrines it in the order following its judgment, that Sainsbury's will be bound in any remittal by the concession that it made previously. Sainsbury's said, we accept that there will be a minimum lawful level of the MIF. We did not. And secondly, the Court of Appeal made clear that in our proceedings, as you have seen, MasterCard agreed that our interpretation of the fair share condition should apply irrespective of Visa's appeal. So there are 2 material differences already. In its written response case, MasterCard says very little on this. It says in paragraph 27 that the Court of Appeal was not assuming that there would be consistency between all 3 cases, but that it might be possible to reach a consistent conclusion based on the evidence available. In terms of the written response case, as clarification, my lord, you should have a loose, separate copy because they replaced the original version.
Oh, we have this in the core volume.
That was the first version.
Oh, I see.
It was then replaced because they had appended to it the wrong document. So just to avoid any confusion.
The text of the written case didn't change. It's only the appendix that the text changed.
That's absolutely right.
Fine, thank you.
Yes, but for clarification, if should it be necessary, that it's the replacement that governs. So the suggestion in paragraph 27 of their written case was that it was merely saying, the Court of Appeal, that it might be possible to reach a consistent conclusion based on the evidence available. Now, when one looks at paragraph 366, it's clear that that is not what the Court of Appeal was saying. The Court of Appeal says in terms the same principles would be applied consistently in all three cases, so leading to a consistent outcome. It was in error in making that assumption because it contradicted other parts of the judgment and order to which I have referred, where it recognised that there would be those necessary differences because the litigation had taken different turns. Even more fundamentally, we say that the Court of Appeal was putting the cart respectfully before the horse, because the first and primary question for the court should have been to ask itself, has justice been done between the parties in this litigation on the grounds that MasterCard has had a full and fair opportunity to put forward its case and such evidence as it is inclined to do, and that it ought to have lost at the trial? If the answer to that was yes, as the Court of Appeal's judgment says it should have been, then there should have been a final judgment as the consequence in AAM's favour. It's only in circumstances where there's an independent, legitimate need of some kind or other to remit in our case that the court should then turn to consider the modalities of that remittal as between three different cases and ask itself at that point, how should we deal with what evidence should be available between one case and another? But there was a prior question first. And my fourth and final point is this. The Court of Appeal described the fact that our case had been tried separately from the other two cases at all, as you'll see from paragraph 366, as a procedural mishap. That's letter E, 2 lines down, and just at the end of the paragraph, as a procedural accident. It was not. There are scores of these damages claims for interchange fee competition law infringements currently pending in the English courts. There were 3 sporadic initiatives to have different combinations of cases, small numbers joined for case management or for trial in respectively 2013, 2015 and 2016. And at each of those stages, there were legitimate reasons why the cases remained separate based on the interests of the parties. We've referred to these in the bundle. In 2013, there were 3 sets of proceedings, and there were different issues raised between the parties at that point on limitation, on the scope of the claims, on ex turpi causa, and a range of other matters. And a decision was made on that basis. In 2015, my Lord Hamblin, then at first instance, made a ruling, which is in the cross-appeal bundle at page 8127, equally saying that there were reasons not to combine certain of the cases for good litigation reasons. And finally, in 2016, there was a late question raised as to whether the Visa and MasterCard trials should be joined at that stage, and there were objections from, I believe, pretty well all the parties, including Visa and MasterCard, saying that to put these 2 actions together at this point would involve a host of difficulties with confidentiality, delays, and we're not prepared to countenance those. and so the court went ahead. Even with hindsight, if it might appear better that all of this interchange fee litigation had been centrally managed in a different way, that's not to say that our trial, our private law litigation, was unfair to MasterCard, or that the victorious claimant should now be put to the necessity of a further hugely expensive and time-consuming process. This is a case where there are compelling reasons to accord to AAM final judgment based on the reasoning and the conclusions in the Court of Appeal's decision.
It might be said there's a more fundamental issue involved here than whether or not the right decisions were taken in terms of case management and whether or not you'll be put to additional expense. And the fact of the matter is there were 3 separate trials, and it wouldn't ordinarily be either fair or just for the result of one trial to be determined on the basis of evidence in another trial, which a party had not had an opportunity either to cross-examine or to rebut by leading other evidence. I mean, that's a fundamental point.
We agree with that too. This is an aspect of what we perceive to be the Court of Appeal's objective to reach the right answer, as it were, some objectively coherent right answer, rather than looking at the justice of the individual case. If you approach it with the ordinary eyeglasses of the English approach, you look at the trial that has taken place, the chance that the parties have had to put forward their evidence, and the fairness as between the parties. It's Lord Wilberforce's point in Air Canada.
Yes, I mean, is there anything I'm missing?
No. Well, you may
I'll
have.
never be told, but normally if you wanted to be able to take all the evidence into account, you can join the trials. And if you're not doing that, then each case has to be determined on the evidence led in that trial.
Yes. Well, absolutely. And I say again, paragraph 244, the reasoning could not be clearer, that it was MasterCard's litigation choices that put it in the position that it found itself. My Lord, those are my submissions.
Yeah. Well, Mr. Hoskins, what's the answer?
Oh, give me a minute to work up to it. The cross-appeal, of course, doesn't arise if the court finds for the schemes on issues 1 or 2. But let's assume we're, at least for the schemes, in that unhappy position. Let me first of all set out what the framework is for the Supreme Court considering this issue, which Mr. Turner has ignored. Can we please go to Additional Authorities 11, Authorities 11, tab 94, 4539. Which are the civil procedure rules? Because these are the powers pursuant to which the Court of Appeal made its order remitting all 3 cases back to the Competition Appeal Tribunal. And you'll see sub 2, the appeal court has power to B, refer any claim or issue for determination by the lower court, or C, order a new trial or hearing. So the Court of Appeal has power to do those things. Now, it's not in dispute that the Court of Appeal had power to make the order that it did. You see this in AAM's own written case in the cross appeal, where they refer to it as being a power. So Core 1, tab 18, 4967.
It doesn't have the power to deal with cases unjustly.
No, absolutely.
That's the overriding objective, one of the overriding objectives, of
I'm
course.
certainly not going to push back on that proposition, my Lord, absolutely. Paragraph 22, which Mr. Turner just took you to. So AAM says, within this context, the essential point raised with this cross-appeal is a short one, but it raises an important issue concerning the principles that an appellate court must apply when exercising its discretion under CPR Rule 5220 to dispose of an appeal. So there is common ground between the parties that the Court of Appeal had a discretionary power to make the order that it did.
But I mean, it's very frequently the case that a court appears to have a formal power giving it a discretion. You may do such and such. But in the particular circumstances, there's only one possible answer consistent with underlying principles of justice and fairness and so on, which dictates the result, even though formally it's a discretionary power.
That is a possibility, but it's not this case for reasons I'm going to describe. But all I'm doing at the moment is establishing that there's common ground between us, that we're dealing with a discretionary power under the CPR, and what the cross appeal actually therefore concerns is the manner in which the Court of Appeal exercised that discretionary power under the CPR. Now, that is important because it's well established that an appellate court, including this court, should not reverse or otherwise interfere with a discretionary exercise of power under the CPR unless it could be shown that irrelevant material was taken into account, or relevant material was ignored, or there'd been a failure to apply the right principles, which is my Lord Sale's point, or if the decision was one which no reasonable tribunal could have reached. That's well established. We've given you the authorities in our written case, so given that Mr. Turner hasn't cavilled with them, I don't think I need to turn them up, but I'll give you the references again. BPP Holding against Revenue and Customs Commissioners, that's authorities 4, tab 36, page 2061. And in addition to the head note, it's Lord Neuberger's speech at paragraph 21, which is MS 2069, and paragraph 26, which is MS 2071. And Lord Neuberger cites Global Torch and Apex, which again was actually a judgment by Lord Neuberger. And the reference for that is Authority 6, tab 43, page MS, page 2607, and that's Lord Neuberger at paragraph 13. So that's the framework for considering the cross appeal. It's not simply a decision de novo, if you like, by this court. It's within the constraints of the review of a discretionary power. Now, our submission is that the decision by the Court of Appeal to remit the AAM claims was within the ambit of its discretion and was not inconsistent with any particular principle, and that's why the cross appeal should be dismissed. Now, we're dealing here with the reasonable exercise of discretion. Now, AAM has prayed in aid what it refers to as quote-unquote principles, that first of all, the court is concerned with doing justice between the parties and is not a searcher after truth. And secondly, the importance accorded by the English courts to achieving finality. Now, in our submission, there's no doubt that the Court of Appeal was aware of those considerations. One can see that, for example, in paragraph 365 of the Court of Appeal's judgment, Court 2, MS 5281. It's paragraph 365. The court, and this is right at the end of its judgment, before it comes to the decision to remit and the reasons therefore, the outstanding question is then whether, when AAM and MasterCard goes back to the CAT, it should be open to the CAT to reconsider the applicability of the Article 1013 exemption. We are conscious that we have held that Mr. Justice Popwell ought to have concluded on the evidence that he heard that MasterCard's claim for exemption under Article 1013 failed. So it can't be said that the Court of Appeal failed to take account of a relevant consideration, i.e. its own earlier finding, because it recites that earlier finding immediately before it makes the decision to remit. Now, whilst the need to do justice between the parties and achieving finality are clearly relevant considerations, were relevant considerations for the Court of Appeal to take into account in exercising this power, they are not the only considerations. And they are certainly not prior considerations, as Mr. Turner suggested. There is no hierarchy of relevant considerations when exercising this power. But we accept that finality and doing justice between the parties are relevant considerations. But in the Court of Appeal's view, there were other relevant considerations which led it to take a view that there should be a remittal. And there were two other considerations that it relied upon. First of all, the need to do justice between AAM and MasterCard. And second, the desire to facilitate a degree of consistency of result in the three cases before it.
So why hadn't justice already been done between AAM and MasterCard?
I'm just about to come to that one.
All right.
If I deal with the first heading,
Certainly.
need to do justice between AAM and MasterCard. Now, Ms. Turner has shown you paragraph 366 of the Court of Appeal judgment, so that's Core 2 MS 5281. And the Court of Appeal said, we take the view that despite what we have said above, it is not certain that had Mr. Justice Popplewell had the benefit of this judgment, and thus been fully aware of the need for empirical data and facts in order to prove an exemption, MasterCard's case in Article 1013 would have failed in its entirety. It is possible, bearing in mind the acceptance by Sainsbury's and the CAT in the other two cases that there was a lawful level of MIF, that the judge would have found that there was some acceptable level of MIF, albeit a lower one than he in fact found. Altogether, removing the Article 1013 issue from reconsideration could therefore result in an unjustified windfall for the AAM parties. Now, the first question when approaching this is to ask, well, was that a relevant consideration? Was it a consideration that the Court of Appeal was entitled to take into account? And in our submission, a desire to do justice as between the parties is clearly a relevant consideration to the CPR Rule 52 power. So the second question that must be asked, whether that was a reasonable view for the Court of Appeal to hold. And it is clear from the language, you'll see just above D, it is possible, bearing in mind the acceptance by Sainsbury's and the CAT, etc., that the Court of Appeal considered that it was possible that despite what it has said before, that Mr. Justice Popplewell, on the evidence before him, might have found that the evidence demonstrated that there were lawful, albeit lower, levels of MIF. And our submission that was not an unreasonable belief, because, of course, the Court of Appeal hadn't seen all the evidence before Mr. Justice Popplewell. It had heard submissions from the parties, but it was not in the position of the trial judge. So it was not an unreasonable view for the Court of Appeal to take the view, without having seen all the evidence, that it is possible that Mr. Justice Popplewell might legitimately have come to a view that there was an acceptable level of MIF, albeit a lower one. And what it says is that it looks at the other cases, not to apply the evidence in them, in this case, but just to make the point that in the claim by Visa, Sainsbury's had conceded that lower levels of MIF would be lawful. So that, according to the Court of Appeal, bolstered its view that it was possible that Mr. Justice Popplewell could have come to the same conclusion as Sainsbury's, i.e. that there was a lower level of lawful MIF. And they also noted that the CAT had found that lower MIFs might have been lawful. And the CAT had based its exemption analysis on the issuer costs approach. And our expert before the Court of Appeal had relied both on an adjusted MIT and an issuer cost approach. And Mr. Justice Popplewell had found that he preferred the adjusted MIT. He wasn't very keen on the issuer cost approach, but that it did, to a certain extent, confirm the finding he based on the adjusted MIT. So the point is, was it unreasonable for the Court of Appeal, not having seen all the evidence, to take the view that it is possible that Mr. Justice Popplewell, applying the Court of Appeal's principles, might have reached a different decision? We say that was clearly a perfectly reasonable position for it to take.
Well, they had earlier held, paragraph 258, that the judge should have concluded on the basis of the evidence before him that the first condition was not satisfied.
Well, my submission in relation to that is absolutely right, that's what it says.
And at 259, had the judge carried out the balancing exercise, he would inevitably have concluded that MasterCard couldn't satisfy the second condition
I
either.
understand. The tension there, in my submission, resolved. You cannot read the judgment or each bit of it as if it were a statute. It's a submission you're used to doing.
I'm so sorry. Well, I mean, just suppose Mr. Justice Popperwell did what the Court of Appeal said he should have done. The proceedings would have been closed at that point.
Sorry, I don't understand. Well, that assumes that there was nothing in the evidence before Mr. Justice Popperwell that could have justified a lower level of MIF. And my point is, that the point in answer to Lord Reid's point was, on one hand, you have the Court of Appeal says inconsistent things. On one hand, it says there was no evidence to show extent of issue or pass-through. There was no evidence of all those card transactions. And then later in its judgment, it said it's possible that on the evidence before him, Mr. Justice Popperwell could have reached a view that there was a lower level of MIF. So there is an inconsistency in the judgment.
Well, does it? Does it say? Is it possible, on the basis of the evidence before him, he could have found an exemption?
Well, that must be what it means.
I wonder. I mean, the order obviously allows allows other evidence to be taken into account, and in what? For example, what does the concession by Sainsbury's have to do with AAM's case against MasterCard?
Well, my Lord, as I said, my submission is not, and my submission, what the Court of Appeal was not saying was, Mr. Justice Popperwell could have relied on the Sainsbury's concession, said that's the answer in the dispute between MasterCard and AAM. The only reason he refers to the concession is to show that Sainsbury's had taken the view that there was a lawful level of MIF, and the Court of Appeal is relying on that to say, therefore it is possible, that bolsters our view that it is possible that Mr. Justice Popperwell could have reached the same conclusion as Sainsbury's. It's not saying that Mr. Justice Popperwell could have relied on the conclusion to base his finding that there's a lower level of lawful MIF. Mm-hmm. All it's saying is, look what's happened in the other cases where a lower level of MIF has been established, first of all by the tribunal through an assessment of the evidence before it, secondly by a concession by Sainsbury's. But it's not saying there that Mr. Justice Popperwell, if he had had the benefit of the Court of Appeal judgment and the Sainsbury's concession, which didn't exist at that date, could simply have said, I rely on the Sainsbury's concession, and that's the answer. If you like, it's sort of a corroborating evidence of the reasonableness of the Court of Appeal's own opinion that it is possible he could have reached that view. And I think it is important, just to finish this point, yes, is there an inconsistency in the Court of Appeal's judgment? Yes, there is. But it doesn't mean that you have to prioritise one over the other. Why is it the case that when you have a finding saying there was no evidence, that should take priority over the later statement that it is possible that Mr. Justice Popperwell could have reached another view? And in our submission, if one is to, I don't think it's necessary, but if one were to say, well, what one can be right, it's safer to say that the it is possible is right, because the Court of Appeal didn't see all the evidence. How can it have taken a didactic view without seeing all the evidence? There was nothing that could have supported this or that. I accept the judgments in very trenchant terms in that part, but you must read it together, and you cannot assume that one bit of the inconsistency trumps the other. Can I deal with the second consideration that the Court of Appeal relied upon in order to remit, and that's the desire to facilitate consistency, and that's the second half of Court of Appeal's judgment at para 366. So again, Court 2, page 5281. It seems far more just to us that the issue should be reconsidered in all three cases based on the same principles by the same tribunal. There's no real injustice to the AAM parties in the course we propose, since the windfall to which we have referred would have arisen from the procedural mishap caused by the separation of three cases raising almost identical issues. And it's quite clear the Court of Appeal was very concerned about the fact that there had been three trials considering effectively the same issue with three completely different results. And so the Court of Appeal was concerned to try and bring some consistency into this field, not least because, as Mr. Turner alluded to, there are scores of other cases which raise exactly the same point. So the desire for consistency is very strong by the Court of Appeal, and we say is a very reasonable and understandable desire. Then it went on to say the next sentence, if the CAT is now able to reach a consistent conclusion in all three cases on the exemption and quantum issues, this will produce a fair and just outcome for all the parties. So the Court of Appeal was not, contrary to what Mr. Turner suggested, assuming there would be a consistent approach, but it was saying at least there would be a possibility of a consistent approach, and that would have obvious value, not just in these three cases in terms of doing justice between these parties, but generally for the scores of other cases that exist. It would be a triumph of form over substance if we were to hold that we were unable to reach a just solution simply as a result of procedural accident. So what the Court of Appeal was actually doing was belatedly, having seen the way in which the trials had developed, was taking a case management decision. Now let's again go back to the framework of how one has to assess the exercise of the discretion by the Court of Appeal. First of all, relevance. Our submission, it was clearly a relevant consideration to take account of the overall procedural context in deciding how to exercise its discretion under CPR Part 52.20. No issue re-relevance. So was it a reasonable consideration to rely upon, trying to introduce consistency, not just in these three cases, or not just for these three cases, but given that there are scores of other claims which raise precisely the same issue? In our submission, that clearly was a reasonable view for the Court of Appeal to take for the following reasons. As I've already submitted, the Court of Appeal's decision to remit was not based on an assumption that there necessarily would be consistency if all three cases were remitted. But what it was saying, as you see from the language, if the CAT is now able to reach, it was saying that it was desirable to create a possibility that there might be consistency on the evidence available. And even if perfect consistency doesn't ultimately prove possible, I think it's fairly obvious, given all the people assembled in court and the efforts to get here, the various courts we've been to, some consistency in this field is clearly more desirable than no consistency. Now I come to the available evidence point, because what the Court of Appeal could have done was it could have allowed, say we're going to remit the matter, and we allow the parties to rely on new evidence. That was clearly within its power as well. And it decided not to do that. It expressly said we won't allow new evidence. But they took the view it was preferable to allow each party to rely on the evidence in the other proceedings. The part of the order saying that each of the parties can rely on the evidence in the other proceedings, with respect to Mr. Turner, hasn't been challenged by his clients. One finds no hint of it as a challenge in their papers for this case, indeed even in their written case. That bit is not challenged. So that's the order that the Court of Appeal has made. I understand Lord Reid's point to say, well, how does that deal with the fact that there's evidence in other cases? But of course, AAM did get to challenge the visa evidence in the visa trial, because it played a full part in that trial and settled. I wasn't there, but I think Ms. Rose said, right at the end, I think after Ms. Rose's closing submissions, written closing submissions. So, well, I understand the point you raise, but it depends on the facts of each particular case. And in this particular case, AAM did get the chance to play a full role in terms of challenging the evidence in the visa proceedings. Now, if that was a concern for the court, if that was the only concern, that particular part of the order, even though it's not been challenged, of course, there is another solution. If you think the Court of Appeal was right to seek consistency, then this court might take the view, well, we're going to leave in place the remittal, but we're going to allow the parties to rely on new evidence. And that might be a preferable position to the one that's adopted. But in terms of the critical legal criteria of relevance and reasonableness in our submission that the decision taken was well within the Court of Appeal's power.
If the court adopted a reason for which there was no factual backing, that would be a ground for challenging the exercise of discretion and would require this court to reconsider.
I'm sorry, I missed the first part of that.
If the court below, in exercising a discretion, gave as one of its reasons something for which there was no factual basis, that would be a reason for calling into question its exercise.
No factual basis as opposed to a reasonable factual basis, then yes, that would be a reason for interfering with discretion.
Well, when they speak about a windfall as a result of a procedural mishap or accident, where is the evidence of a mishap or accident standing what Mr. Turner has told us about conscious decisions being made?
Well, I think that is a reference to not mistakes being made as such, but just the fact that as a result of the case management decisions taken, there were 3 separate trials with 3 different outcomes.
So you think it's just a question of language rather than saying that it was in fact accidental. It's simply case management decisions which Absolutely. The court thinks were unfortunate.
Absolutely.
Thank you.
Absolutely. And I think in relation to this issue of case management, I mean, Mr. Turner has sought to rely on the fact that these 3 claims were not consolidated before trial. And I won't go through the details of the various attempts made. I will point out that MasterCard was the first to try and actually have them all joined together, but wasn't successful. And the final time in which it was considered was after the tribunal had already heard its trial, and after our trial in relation to AM had already started. So it was that late in the day. And I think the Court of Appeal's view, I think it's fair to say, it's clear from this judgment, whatever case management decisions were taken at first instance, the Court of Appeal is clearly taking the view that it is desirable to hear all 3 appeals together because of their similarity. It also quite reasonably took the view that they should continue to be heard together following the appeal. I mean, this is, in essence, the Court of Appeal saying we are now going to take a case management decision that we think is the correct one, which is they should all be dealt with together. Lords, those are the submissions I wish to make, unless you have any further questions for me in relation to this.
Well, the only point that occurs to me is that this issue, which I at any rate have raised about Order 15 allowing effectively evidence in one trial to be evidence in all the others, has an effect not only on AAM but on other parties represented. So if there are others who want to make submissions on that, I think they ought to have an opportunity to.
Well, very, very briefly, the only point I would make is that Mr. Hoskins has just floated the possibility that there could be remittal with fresh evidence. Yeah. That's not a matter that's ever been raised in this appeal, and Visa's had no opportunity to consider it. My understanding is that there's never been any appeal against that part of the Court of Appeal's order, and for Visa's part, we would submit that there's no proper basis for that being interfered with. It would obviously have very significant cost implications.
If fresh evidence would be allowed.
Yes, enormously significant, Lord.
Yes, appreciate that. Really?
Well, only that we would agree, if one looking at the order, clearly, I think everyone was agreed that no fresh evidence should be adduced on the remittal and no new argument. But we do take the point about having to, we're stuck with evidence in one proceedings when we haven't had a chance to cross-examine.
Yes, so you would adopt that point.
It's that position, but we do support the order which says no fresh evidence and no new argument. Come on.
I don't think the suggestion was that parties couldn't make submissions, but simply they couldn't amend their
That's
case.
Right, yes. Fine. Well, I think then it's for you to reply, Mr. Turner.
My Lord, yes, and I have a number of fairly brief points. First point, Mr. Hoskins directed you to paragraph 365 of the judgment, which introduces the reasoning in 366. I ask you to pick that up again and ask you to look at the second part of that judgment below letter B, the second sentence, because it is revealing. Since, however, the first sentence says, the second sentence, I should say, we're conscious that we've held that Mr. Justice Popplewell ought to have concluded on the evidence he heard that MasterCard's claim for exemption failed. That is true. They then go on to explain their reasoning. Since, however, the schemes in the CAT case and in Sainsbury's and Visa will have an opportunity to re-argue, since the others will have an opportunity to re-argue the exemption issue based on the principles set out in this judgment, we have considered whether MasterCard should have the same opportunity in AAM's case, even though it has not filed respondent's notice. You see from that, therefore, that the driver behind the Court of Appeal's decision to remit, explained in the following paragraph, was indeed, as your lordship has supposed, the remittal of the two other Sainsbury's cases that caused the decision to remit. Second point, within paragraph 366, Mr. Hoskins focused on the proposition between letters D and E. This was the acceptance by Sainsbury's and the CAT in the other cases that there was a lawful level of the myth. And he referred to this in the context of the Court of Appeal exhibiting here a desire to do justice between the parties. He said that that's what you see coming off the page at that point. However, the reference here to the Sainsbury's concession and the attitude taken by the tribunal in its case as the indication that justice was not done between AAM and MasterCard is unreasonable or wrong in principle. That is not correct. Third point, Mr. Hoskins referred to an approach that was firmly rejected before Mr. Justice Popplewell, an expert approach that he called the issuer's cost methodology. There is no suggestion in the reasoning of the Court of Appeal that that methodology was something that the judge should have accepted and should be a basis for remittal at all. On the contrary, they say that he should have found that MasterCard fails at trial because it fatally omitted to bring forward evidence on other points, the issuer evidence points. There is nothing which touches that decision of theirs, and it was correct and unassailable. Fourth point, Mr. Hoskins says, why, if there are two inconsistencies that you see in this judgment, between on the one hand the reasoning in the substantive part, and on the other hand a statement in the disposal part, why then should you give priority to the reasoning in the substance of the judgment? The answer is that the reasoning in the substance of the judgment tells you what should have been the basis for what was done in the disposal section of the judgment. That is the way in which this should have been decided. Fifth point, Mr. Hoskins says that the Court of Appeal was concerned to achieve consistency, not least because of the scores of other cases in the courts. However, a remittal in the cases before you of these three matters would not determine MasterCard's position or the other litigants' position in those other pieces of litigation, where they are free to bring forward such evidence and make such submissions as they choose. That was a point which we made in writing, and the response to it is given in paragraph 30 of Mr. Hoskins' written response case. He said, the fact that the determination of these three cases will not determine all the other pending claims against Visa and MasterCard does not mean that it was unreasonable for the Court of Appeal to seek to permit some degree of consistency across these three claims. Again, some consistency is better than no consistency. So the point reduces to a contention that some consistency is better than none. And that is my sixth point. That is a proposition that goes nowhere because justice between the parties is the touchstone, and that should not be denied. In this litigation, AAM has been denied the finality that it should have received, and faces instead, if this continues, very expensive and time-consuming litigation, which it should not. And my seventh and final point is this. It is said that we do not challenge the cross-admissibility of the evidence in the order. Well, what we do say is that we should not be put in this position at all, to underline the submission I made earlier about putting the horse before the cart. There was a fair trial. The result of that should be that there should now be finality. My Lord, that is my reply.
Well, thank you very much, Mr. Turner. We're grateful to all counsel for the quality of the submissions that we've received in this very complex case, and grateful also to all those sitting behind who no doubt have also contributed. Well, we'll now take time to consider our decision.
Are we going to put any submissions in on the...
Oh, yes. On the broad axe issue. Yes. Well, it would be helpful if you could let us have those, if we were to say 3 weeks from today, would that give you enough time?
My Lord, there's also the issue of the court's powers in terms of a reference to the CJEU.
Yes.
Again, in my submission, that would be best dealt with after the final terms of the legislation have passed.
That's true.
And probably after the 31st of January.
Yes, and we don't know when I mean, a lot of the devil may be in the detail of the delegated legislation.
Yes. My Lord, can I suggest that we set a date of the end of February, which will give us a little time to see exactly what the law is before we seek to tell your lordships what we consider it to be.
Yes.
That would give us 4 weeks from the implementation of the legislation.
Yes. It's quite good for us to be able to make progress so far as we can while things are still fresh in our minds. I agree end of February for a sort of agreed position paper on the EU issues.
Yes, my Lord.
The broad axe issues, I think we might have a bit sooner than that.
Yes.
Well, if 2 weeks would suit you, then fine.
Look, can I just clarify, because it said written submissions on the broad axe issue, but I think you don't want submissions on the broad axe. You want submissions on the sort of broader burden of proof point. I just wonder...
Yes.
This may be cheeky, and if it is, you will tell me straight away.
No.
It would be helpful if the court were to formulate the issue you would like the submissions on, because otherwise there's a risk that we just give you lots of stuff that you don't want to.
Well, I think the transcript should make it fairly clear what concerned us. It's essentially the... on one approach that's been put to us is that the claim is for the myth, and it's necessary for the defendant to raise by way of defense the issue of pass-on, and the defendant will then bear a legal burden of proof to discharge, to establish that there has been pass-on, and on that hypothesis you then have the broad axe point. And what we've put to you is an alternative analysis that the claimant has to establish the extent of its loss, and that that legal burden remains on it throughout, and that questions about pass-on arise within that context. And again, there may be issues about the degree of precision that can be expected, but really the broad axe point is really a subordinate one to the issue about how do you approach where the burden, what it is that has to be proved, and on whom the burden lies to prove it.
Yes, so as I understand it, it's not the broad axe, the narrow broad axe point that is our issue 4, it's the point that's been raised by the court, which is is a separate issue. Really.
Yes, I mean, I think on whomever the burden lies, I don't think it's going to be terribly difficult to persuade us that a precise quantification is not going to be possible. The more important issue is, for the parties, is really how should this question be properly approached?
I'm looking for authority on the proposition that where the claim is one of damages, that the burden is on the defendant to establish pass-off. And also if you can cast any light on the suggestion that there is that burden on the defendant, but somehow a very high evidential burden on the claimant. What is the content of the legal burden on the defendant, if there be such?
That's very helpful. Thank you very much.
Thank you. The court will adjourn.